Hi, I'm Mike Devlin, and this is Opening the Door to Family Law. It's where I invite you into my kitchen, and with special guests, we talk about the nuts and bolts of the family justice system. And today, I'm absolutely delighted to welcome Iain Hamilton, an old friend, a colleague, a mentor, an inspiration, and a fantastic lawyer and judge. Iain and I met in the 1980s when we were both solicitors. We both specialised in the law relating to children, and in particular to children who had been removed, or there'd been an application for their removal by a local authority because they were said to have been neglected or abused. At that time, local authority cases appeared in the juvenile court. So often we met in the juvenile court in the corridor, particularly of Manchester City Juvenile Court, where there was a small group of specialist solicitors who got to know each other extremely well, and we'll talk about that in a bit more detail shortly. Iain qualified as a solicitor in 1974. In 1992 he was made an assistant recorder, 1996 he was made a recorder, and in 2000 he became a circuit judge. He became the designated family judge for Manchester in 2010 and 2005 and served with distinction until his retirement in 2018.
2014.
You're joking.
I retired from sitting as a full-time judge. I retired as a DFJ 3 months before I actually left.
Right. I can't believe that. But it's probably the best decision that he made, because he looks younger now than when he was working full-time as the DFJ.
But I did carry on sitting as a family judge until 2020 on a part-time basis.
Yeah. So not only was Iain a fantastic solicitor, a brilliant judge, but he also served the family justice system in many other capacities. He was the chair, founder of Child Concern, a multidisciplinary group in Greater Manchester and the North West, which continues to this day, and has been instrumental in providing training and a forum for debate amongst family lawyers, judges, social workers, CAFCAS officers, and medical professionals, and is still going strong. Now, Iain, do you remember us meeting, or around the time when we first met?
Not really, no. What are you going to remind me about now?
No particular incident, but I can remember time spent in the corridors of Manchester City Juvenile Court.
And also the Stockport Juvenile Court.
Yeah.
And I can remember you and I talking about other solicitors when we did meet up occasionally for coffee, when the magistrates all retired at 11 o'clock. They were interesting days, I have to say.
They were.
Yes.
And at one time, Iain, you may or may not recall, we thought about setting up a firm of our own.
Oh, that is going down the line a bit, isn't it?
It is.
Yes.
And we were so sophisticated that we even drew up a business plan, which, if I recall correctly, was on the back of one of your embassy cigarette
Almost certainly, yes.
Fortunately, we both made probably the best decision that we'd ever made in our career.
I think that's right, yes.
And you chose to stay where you were. Well, you moved to...
Well, I moved to Jones Maidment Wilson in Manchester,
which was
as a result of that, which was a good thing to do.
A very good thing. And then I moved to the firm where I was for many years, Stevenson's.
Stevenson's, yes.
And built up
A remarkable family law practice, I have to say. As a judge sitting on the outside, it was quite remarkable, the team of lawyers that you were able to put together and the service you were able to provide to the public.
Yeah,
basically.
So we both went our own ways, but we remained firm friends.
And we still do.
And we still
I
do.
hope.
Of course, yeah. Now, I just want to know what the origins were for you becoming involved in the family justice system, because you weren't always simply concentrating solely on family law. So
No.
What drew you to family law?
As a student doing a degree, family law and criminal law were the only subjects that truly interested me. The rest of the legal subjects that we had to address, conveyancing, inland revenue law, company law, left me cold. I was very fortunate because I did my degree, finished it in 1970, did my solicitor's qualifications in 71 and a bit later, because I didn't pass all the exams at the same time.
Another thing we have in common.
I am probably one of the judges who was the least academically qualified and able. And I said at my valedictory that whenever you went into a courtroom and I was sitting, I was probably the least gifted academically person in the room, actually.
Apart from me.
Apart from when you were there. But I was fortunate in that my training coincided with the implementation of the Matrimonial Causes Act. None of the partners in the firm that I joined knew anything about that, so I had a head start on them. We had 4 magistrates' court advocates who dealt with quite a lot of matrimonial work in the magistrates' court at that time, because very little work was done in the county court at all. And it was as a result of being able to follow in their footsteps as an advocate in the magistrates' court that I started doing juvenile court criminal work, and then fell into doing juvenile court care work and parental rights resolutions cases, which came before the magistrates when they were being appealed.
And just to clarify, when we say care, we mean where a local authority on behalf of the state is intervening in family life.
That is right.
To remove a child or to in some way to take over the role of parent for the child.
Yes, because they were allegedly abusing or failing the children in significant ways.
Yes.
And I remember I did one of the first contested care cases I ever did was in 1975. It took 3 days, and it was a case where the parents were alleged to have poisoned one of their children. In fact, we were able to demonstrate to the magistrates that that was unlikely to have been the case, so they weren't able to take the children away from those parents. That is a case which, had it been dealt with in any time after about 1986, it would have been a High Court case, but it was being dealt with by the magistrates.
Yeah.
And a lawyer who'd not been qualified for 12 months and who wasn't being paid for doing the case. I did it on what used to be called the green form, which I was able to extend, I think I'm right in saying 3 times, so I got paid for doing 9 hours work, where I was actually in court for over 3 days, to say nothing about the preparation.
And in those days, legal aid wasn't available for the parent.
That is absolutely right. It was only the child's representative that got the legal aid. Yes.
And both of us will recall, because I remember the individual who, we don't say prosecuted, but brought cases on behalf of the local authority in Stockport. And there was another chap who did the same in Manchester, neither of whom were lawyers.
No, they were social workers, both of them, yes.
Very dedicated, very hard-working, but they weren't...
Reasonably capable, but not brilliantly so.
Yeah.
Absolutely.
And sometimes would be handling
complicated medical cases and 3 or 4 cases in the same day.
Yeah.
But remember, in those days, there was very little evidence that was realistically given to the court. And if you were representing parents, you weren't entitled to see any documentation or evidence other than the social inquiry report prepared by a social worker to make a recommendation to the magistrates if they found that an order needed to be made.
So, and a social inquiry report was effectively a summary report. It wasn't a statement of evidence.
That's right, yes.
Yeah.
Yeah.
And these were cases which were being dealt with in a very short time scale.
Yes.
Making decisions for the removal of children who might then be permanently removed, adopted.
Yes, and with the children not necessarily having, good representation, certainly no social work representation, until the Guardian ad litem service started in 1984.
Yeah.
Which was about the time you started, I think, wasn't it?
A little bit. I qualified in 1981, but I became
there you go.
more involved in the family justice system towards that period of time, and that's when things really did change, didn't they?
Yes, significantly. The 1980s, there was so much change. It was remarkable because that's when the Police and Criminal Evidence Act, of course, came into being to deal with criminal cases. The Guardian ad litem processes all came into force at the same time as well.
And just to clarify, the Guardian ad litem service provided that any child who was the subject of care proceedings would have a children's guard, a guardian ad litem, an independent social worker, and legal representation. They were allowed to choose their solicitor, and that was a very important factor in you and I being able to develop the practices that we were able to grow. Yeah. Because if you did a good job for a guardian ad litem, they would recommend you to other guardians ad litem, or they would give you another case as and when they got one. So yes. So we developed very busy practices, ranging around Greater Manchester, not simply in our own local court.
Yeah.
Because at that time, the guardians were taken from either local authority departments or some of the charitable social work agencies.
Yes.
And a social worker would not report in their own area. So they would then someone from Manchester would go to Stockport, or someone from Oldham would go to Bury.
That's right.
And we ended up going all over Greater Manchester.
I can remember going to Lancashire on regular occasions because there was a particular guardian out there that liked me to challenge local authorities and the way they thought. I did a lot of work in Cheshire. Very privileged, I have to say, to be able to do it.
Mm.
So, yes.
And so cases suddenly changed. They weren't all in front of the magistrates.
No.
We ended up being in the county court, the high court, and one of the unusual aspects of this is that we as solicitors were doing our advocacy where it was usually just barristers.
Yes. Once wardship became a tool, and wardship was taking a case in the High Court to ask a High Court judge to make an order to protect a child, basically. Once that came about, there was an avenue for us as solicitors to be able to exercise our rights of audience, because being in chambers, we were able to appear before such High Court judges. And I think you and I were fortunate in that we seemed to rub along quite well with most of the High Court judges who we appeared in front of.
Yeah.
That wasn't true of all solicitors, of course, and some got very short thrift from some of the High Court judges that I can remember.
Yeah.
But anyway.
Well, it's probably better to gloss over
I
that,
think
isn't
you're
it?
right, yes.
But we did have the privilege of appearing in front of some wonderful High Court judges.
Absolutely, yes.
Some not so wonderful ones. But we also had very good working relationships with the barristers as well.
Absolutely.
I have to say that I think Manchester was exemplary in that there wasn't really any prejudice or resistance from the bar in Manchester, which wasn't necessarily the same in all of the different
I think that's true, actually.
areas of the country.
Yes.
But it was very much a collegiate, collaborative atmosphere.
Yeah.
Mind you, they probably made a hell of a lot more money than us, so they weren't. They had good reason to be happy, didn't they?
But we equally used to instruct a lot of them.
We did,
as well as appearing with them and against them on other occasions.
Yes.
So we formed very strong relationships and indeed friendships with a lot of them.
Yeah. One of the things about family law, which I think distinguishes it from other areas of the law, is that it's often quite a team effort.
Very much so.
And that is even where you have parties who are on the other side of a case, that a principle of family law is openness and full disclosure, which is in contrast to criminal law.
Very much so, yes.
Might have changed as time's gone on in the crime. And also in civil litigation, which again probably has changed. But in the family justice system, the expectation was, and the law was, you had to be open.
Yes.
You had to show your hand.
Yes.
And that we also quite often had jointly instructed experts in our cases. And that was also influential in child concern.
Very much so. Trying to encourage experts to join in and share what they knew with lawyers, social workers, guardians and others was one of the founding factors behind actually deciding to set up child concern, because I remember one of the very eminent doctors, Dr. Frank Bamford, really made me think about how we should, as lawyers, think about approaching what we were doing with our clients in a very different fashion and from a different perspective. And yes, it was very helpful in being able to get a lot of experts involved in child concern, and they still are today. In fact, I think the chair, if I'm not mistaken, is a psychologist at the moment, and has been for the last 2 or 3 years.
Yes.
So, yes.
Yeah. Because my understanding is that in the medical profession, at least back when we were starting child concern, it was a very common thing that they would have a mess room, that they would meet, they'd discuss cases. Quite often it would be a multidisciplinary discussion.
Yes.
And by having those sort of discussions, someone bringing a case forward and then dissecting it and looking at the from different angles, it improved their professional performance. It deepened their understanding and their knowledge. And we were starting to do that within some of our cases, because we would have a multidisciplinary meeting, a professionals meeting, where each person brought their viewpoint to the table, and we produced a summary of those discussions to help the court.
Yes, absolutely.
I don't know quite how much that's continued.
I don't know if it has continued.
Today.
No.
But and that then led us to, there was a steering group where we decided, why not have a membership organisation?
Absolutely. And that was in, 1989, I think I'm right in saying?
Yeah.
Which fortunately coincided with the introduction, well, not the actual introduction, but with the formulation of the Children Act in 1989.
Yeah.
So everybody's thinking about the same sorts of processes.
Yes. And that's another milestone in our careers, isn't it?
Very much so, yes.
Yes. Because at the time that the Children Act was received the royal assent in 1989, there were then 2 years before it came into force.
That's right. October 1991, if I remember
1991,
rightly.
Yeah, and it was a very exciting time. And I mean, people might think, "Oh my goodness, what pathetic creatures are that they're excited about a new law being." But the law essentially, it didn't just say this is what you have to do. It then explained how to do it, and there were a series of almost manuals telling you in each situation what you should be doing and how you should be going about it. It was a fantastic piece of legislation.
It was a brilliant piece of legislation, and given that it is still in force today, 32 years later, is quite remarkable actually, and it governs every family case which is determined in either private law or public law.
Yeah. So, again, something that I think is common to both of us, neither of us were particularly brilliant performers at school academically.
True.
Neither at university.
I got a third-class honours degree.
Yeah.
Spectacular.
Well, you know, I'm
surprised to pass, actually.
And we sort of stumbled our way through our professional exams. But then once we actually got into practice, we then we realised we had an appetite for the law.
What really drove me was the ability to help people by using the law as you understood it, which I'd never understood when I was dealing with things like buying and selling houses or dealing with people's estates, all figures and whatever. But it was a very much a living subject, and you were dealing with living beings on a day-by-day basis. And I did, you should remember this, a lot of crime all throughout the time that I was dealing with family law as well, because ultimately when I became a judge, I was sitting 50% of the time in crime, as well as family, for the first probably 8 or 9 years of my
I
judicial career.
I did a lot of crime.
You did?
As well, which was, I think, a good discipline for an advocate, because one of the criticisms that is often labelled at family lawyers is you're really nothing more than a glorified social worker. You're a tree hugger, you're a hand holder, you're a sort of an unqualified psychiatrist.
Yeah. Well, I've always said that sitting as a judge in crime made me an immeasurably better family law judge than I would have been had I not sat in crime.
Yeah.
Because you learnt basically in crime to keep quiet unless there was a purpose for you actually speaking, but to let the advocates do the job of trying to persuade the jury. It wasn't up to the judge at all.
Yeah.
Whereas in family law, it's very easy to step over the line and try to interfere with what people are saying, unless you're very guarded about how you actually do your job.
Yeah. Now, just to give an example of how lively, almost febrile the atmosphere was at the implementation of the Children Act, it was also the same time that Child Concern had its inaugural meeting, which was held at a sold-out Manchester Town Hall.
It was. Chaired by a High Court judge who became Dame Margaret Booth, sadly now deceased. But it was a remarkable event that evening.
It was,
And
I had the privilege of introducing her and introducing the.
Of course, you did.
The organisation, and it was quite. It was an exciting time. It was a time when politics was still quite exciting.
Well,
and, we had some belief in the integrity of the people who were putting themselves forward, even if we didn't agree with them.
That's absolutely right. It was a very different time.
Yeah.
But yes.
So anyway, I don't want to make it look like we're two sad old individuals hailing back to our salad days. But this was a time of change.
Yeah.
It was a time where Parliament had made a decision that children had to be a focus for the courts.
Absolutely.
And that the welfare of the child was the paramount concern for the court. And it was a time where there was a genuine collaborative approach by all concerned. Now, one of the things that people, I think, sometimes find difficult is that we describe the family justice system as inquisitorial.
Yes.
In other words, it's different from crime or civil litigation in that there isn't a protagonist and a defendant. There aren't two people battling it out. But it's meant to be an inquiry.
Yes, as opposed to being adversarial. Yes.
Some people might, if they saw us going hammer and tongs, might say, "You're kidding me, aren't you? It is adversarial the way you're dealing with that particular case. Not every case, but it could get
to the point where you needed to explore things in cross-examination with people who were, you thought, telling lies, and often were. And the only way to do that is by taking something of an adversarial approach when you're cross-examining them.
Yeah.
But that was really the exception to the general rule of just making enquiry about things and the events that had happened and what had caused such a thing to happen to the child in question.
So it's important, particularly for lay people, to understand that if there is tough, pointed questioning, it's not because family justice is adversarial or should be seen as adversarial. It's that we shouldn't be. We should feel free to ask robust questions to get to the truth.
Absolutely.
And particularly given the stakes that we're not playing at anything.
No, they're enormously high.
Yeah.
Because the power to make a decision to remove a child from his or her parents is about the most draconian decision that you can make in a child's life. The only thing outside of that is once you've actually made that decision, if you go on then to approve adoption as being the ultimate option for the child, is the most, I think, single most draconian decision you can make to influence or affect anybody's life.
In any legal
Absolutely
forum.
Right, yes. Yeah.
We can come back to your practice as a solicitor later on, but one of the things that I'm interested to know, and I guess most people who are listening or joining us will be interested to know is, what's the transition like from being a solicitor, an advocate, to being a judge?
I never found that particularly difficult. I think some solicitors do. But remember, before you become a judge, you have to train to become a judge, which is why you mentioned me becoming an assistant recorder. Because that's when I started my training as a judge, and I used to go and sit at Liverpool, Crown Court it was, for a number of years.
Baptism of fire.
A real baptism of fire, I have to say. And eventually
it's a bit like being the supply teacher.
Very much so. You went along for a week at a time or 2 weeks at a time, and you just got given any old case to deal with, and you just had to get on with it. And it was a real baptism of fire for me, because when I went and did my criminal training, I can't remember the last time I'd ever seen a judge summing up in court. And yet you had to do that as part and parcel of your job, sitting as a recorder. You learnt very quickly, I have to say.
Yeah.
When I became a recorder in 1996, I then got the right to be able to sit on some private law family cases. So that's where I started learning my craft as a family judge. So eventually, by the time I became a judge, I was reasonably confident with most of what I was doing,
Yeah.
I have to say.
Also, I don't know about you because I haven't had this conversation with you, but very frequently nowadays, I will say to a client, I'm just going to take myself a step or two back here, and I'm going to put myself in the position of the judge hearing this case, because I think it's the most valuable thing you can do for a client to say, yes, I'm here for you. I want you to tell me your ideal outcome, and I will try and get you to that point. But I always say to the client, I'd like to have an agreement with you.
Yes.
And sometimes they say yes before I've even said anything. And it's, can I be honest with you?
Yes.
And once you have that agreement with the client, it means you can say, right, okay, I'm going to step outside my role as your solicitor. I'm going to tell you how I would see this if I was a judge. Now, if you've done that in practice, then when you actually start to sit as a judge, then it's not going to be a completely new experience.
That's absolutely right. And that's a lot of what I used to do with clients. Although as a solicitor, your duty is to act in the interests of your client. Part of that means being able to show him or her all the way round in terms of the potential outcomes, and to talk to them about different ways in which they can have their case presented, or they themselves can present their case. And that was something that I always enjoyed. But I have to say, losing that when I became a judge was no loss at all in real terms, because as a judge, you're the focal point, and it's down to you to get the information. That's the most important thing in the first place, is to make sure that you've got all the relevant information to make a properly informed decision.
Yeah.
And then listen to what the parties have to say, think about what they're saying, rationalise it, and come to a conclusion based on what decisions you make on the competing points which they make.
Yeah.
Acting always in the best interests of the child,
Yeah.
because that's where you ultimately come to as a judge in the family case.
Thinking back about the transition from solicitor to judge, you must, at times, sitting where you are as a judge, you have a completely different view of the proceedings.
You do.
And we aren't able to give any advice in this series. Any opinions we express are purely our own.
Yes.
But if you were to give a message to advocates, and of course you can do that now on the free in the knowledge that you're not going to be dealing with them.
Yes.
What sort of things made you hold your head in your hands and say, no, don't do that? What?
The most obvious thing that used to frustrate me was when people hadn't read the papers and hadn't thought about the issues and hadn't even defined the issues for the court to determine, because that at the bottom of the pile is what you need to do as an advocate, is to ensure you know what you're arguing for or against. And yet I found in the 14 and a half years I sat dealing with family cases, all too often advocates who clearly hadn't read all the papers, hadn't even thought about determining the issues, even though when we came to introduce the public law outline, that was one of the cardinal issues that they needed to actually address. It was quite remarkable. And the other thing I found very difficult was social workers that didn't actually understand the chronology in relation to the events which had happened to the family that they were dealing with, because they'd never taken the trouble to sit down and think about what they were doing. And yet having a chronology in your head, I think, is one of the most important things when you're representing parties, or if you are sitting as a judge, or you are acting as a professional trying to achieve a good outcome for children. The same is true of experts, of course. They need to have a proper chronology. And most of the good experts that we used to see before the courts had got their art down to a T, I have to say. But there were always some who didn't, and they used to drive me to despair.
On those points, I would inevitably do a chronology just for my own use. And quite often, the exercise of going through the incidents that had taken place, relating, saying what the source was, but just going through that timeline. By the time you reach the end, you knew what the case was about, and you all could almost say, this is how it's going to end. The other thing, and we've had this conversation many times over the years, is producing a statement of case for yourself, which was the facts of the case, the law, the issues to be decided, and then a section application of the law to the facts, and again, going through a document like that would basically tell you the outcome, or what the outcome should be. Sometimes it didn't give you an answer that you were particularly happy with, because, but it allowed you to say to your client, look, here's my opinion for you, and here's how I've reached it. And they might say, well, whose side are you on? I'm sure you've had that before.
Yeah, absolutely right. But I mean, in terms of statements of case, you may, I don't know if you will recall this, but I actually produced for the public law outline the standard statement of case format, which had to be adopted for use in all public law cases in, I think it was it 2012? I can't remember now, but about that time, when I was quite heavily involved in helping Lord Justice Ryder, as he became, or he might then have been, and the then President, the late Sir Nicholas Wall, and subsequently Lord Justice Mumby, to get everything shipshape, if you like, in terms of the implementation of the public law outline. Which changed everything immeasurably for the benefit of children by accelerating the time at which most cases were dealt with in, although it's supposed to be a 26-week timeline now, and I know that's not always achieved. When I became the DFJ in Manchester in 2005, I used to be asked to go through cases which were on the books in excess of 170 weeks, could you believe? And there were a lot of them. 170 weeks.
So that's how long a child was waiting for a decision.
Waiting for a decision to be made sometimes. And the majority of cases would take something in the region of 50 to 55 weeks. And I can remember there was a point in time when we were given a target to try and bring it down to 40 weeks. That was about 2007, 2008, something like that. So to have got to where we are now, or where we were when I finished sitting, because I've not now sat since February 2020, I think has been quite a remarkable achievement, although I suspect if you spoke to other judges who are still sitting, they will say that the timelines aren't always adhered to or anything like it. But I little knowledge about that now.
It may seem strange to those joining us, but there was quite a lot of resistance to having a reduction in the...
There was a huge amount of resistance, complaints, criticisms, you name it. But
we don't like change, do we?
Lawyers don't like change at all, and being sort of straitjacketed into something was counterintuitive for a lot of them. But I'm bound to say I thought it was absolutely necessary, and that's because as the DFJ, I had a proper perspective on what was happening throughout the whole of Greater Manchester and the timeline that magistrates and judges and district judges were taking to deal with the cases within. And some of them were just incapable of being able to manage their cases effectively, it seemed to me.
One of the things that you often found is that judges became almost proprietorial over their cases. They didn't want to let them go.
Well, yes, there are two aspects to that, because one of the things that I encouraged from a very early stage was judicial continuity.
Yeah.
So if you dealt with a case involving a particular family, and that family had another child which came back before the course, the same judge, I always said, should deal with the same case again. Yeah. And you get an awful lot of repeat cases. And I can remember was looking through some information I've got at home on my computer, and I found there was one case where I dealt with that same family on 9 separate occasions over the 14 years I'd been sitting.
Wow.
Quite remarkable. And I was thinking earlier about one of the cases that I finished in 2019. I was dealing with children who had been 2 and 3 at the time they started. And I think they were 13 and 15 by the time I finished with their case in 2019. Yeah. So, yeah.
I suppose it's having that judicial continuity is a bit like when we used to have the same GP. For
yes, I think that's right.
For almost a family could have a GP looking after them from cradle to grave.
But just going back to the original point you're making about the other side of the coin, which is judges being too possessive about the cases which they were dealing with. I found that to be a real failing in 3 or 4 of the judges that I used to manage, and it used to worry me as to why they wouldn't let go of a case or somehow find a way of being able to bring it to a conclusion.
Yes.
Because all too often they just allowed the advocates to generate reasons as to why they should be able to continue dealing with it, which was very unhealthy.
Yeah.
And as a DFJ, sadly, you don't have the power to take judges off cases or to dismiss judges. You've got very little disciplinary power.
Well, it's a strange situation, isn't it? Because you are managing the...
supposedly so, yeah.
But without any real teeth to manage.
That's absolutely right. And even if you went higher up the ladder to the Family Division Liaison Judge, who's a High Court judge responsible for the management of the judiciary, they were powerless too to intervene. Quite remarkable, really.
That brings me to another point, which is something that seems now absolutely essential in every walk of life: feedback. You can't buy anything without having a Trustpilot review.
You're absolutely right.
Review. Yeah. Did you ever get feedback as a judge? Did you ever give feedback? And do you think it's a good idea?
There are all sorts of problems with trying to feed back information about performance in the judicial environment. There was a time when we were required as judges to give feedback about the CAFCAS officers, which I can remember I used to do quite religiously, but most other judges never ever bothered with, and I couldn't enforce them doing that. There's never been any formal mechanisms for providing feedback to other professionals involved in cases. And similarly, no mechanisms to allow them to provide feedback on the judges and their performance. The best you get is informed hearsay via your ushers, court clerks, occasional friends, if you saw them outside of the working environment, and somebody would say, somebody gave you a real knocking about that case that you dealt with last week, Ian. But equally, you used to get letters from parents and others who would praise you for what you had said or done. And indeed, I often had mothers who would be prepared to stand up and thank me for at least being able to listen to them.
Yeah.
Because one of the things I always tried to make a point of doing in a case was to make sure that I actually spoke directly to the parents.
Yes.
Rather than just through their advocates, because I can well remember what it was like going to court with a client and how worried and upset and anxious they used to get.
Yeah.
And it was, I thought, a very important part of my role to help them to understand and feel better about what had happened in the process.
Now, people have their own views about lawyers and about judges, and the degree of seriousness with which they take their role, their job. One of the things that was that you could never hide, Ian, was your appetite for hard work. And the reason I say that is that you fell into the email generation, and at a time when advocates, solicitors, barristers would communicate directly with you. You encouraged people to do that.
Yes.
And very often people were receiving emails from you sent at 3 o'clock or 4 o'clock in the morning. In fact, recently I spoke to somebody who lives quite near to you, who said that their son would sometimes be coming home from going clubbing and see your study light still on in that time of the morning.
Yeah.
Is that an indication of just how onerous the task of a judge is and how seriously you took it?
Probably yes. Although having said that, I've always said that I used to have to work hard to do the proper preparation to make up for my lack of intellect more than anything. But going back to starting email communication, I was probably one of the first judges in Greater Manchester to start using email as a means of communicating copies of orders to parties.
Yeah.
And I was doing that way back in 2002, 2003, because I'd learned what the benefits of email or electronic communication actually were. But having said that, it became a bit of a thorn in the side for a lot of people. But it's a remarkable way of being able to communicate with a significant volume of people. And I remember when I decided to retire, I was able to send out the message giving details of when I was going to go to over 140 people at the same time, which was, I thought, brilliant.
Yeah.
But, you know.
I can remember getting emails from you, and not just me, but this would be going out to lots and lots of people, and requesting that our documents were in something called rich text format.
Yes, that's right.
And, you know, it meant nothing whatsoever to me. But I realise now that Dominic Raab has had to resign for that sort of thing.
Well, yes.
But everyone seemed to just accept it from you. And is it just the way that you said it, do you think? Or?
Well, I think they were just replying to the authority of the judge, weren't they?
Yeah,
it seemed.
I'm sure. or just being completely ignorant as to
Yeah.
what it was you were asking.
But most of them all did it with a good grace, it seemed to me.
Yes.
Even though they might well complain, but and they didn't have to open the emails when they were sent. Of course, most of them only opened after 7 o'clock in the morning.
Just thinking about some real life scenarios, and of course not mentioning any names, but what has given you most satisfaction, firstly as a solicitor and then as a judge? The sort of cases, an individual case or an achievement. What are the things that you remember?
The most memorable case that I dealt with as a solicitor was one which was called the Manchester Satanic Ritual case, which had 13 different parties in it, all of whom were represented by barristers and solicitors. And I think I'm right in saying there were 11 silks that were then Queen's Counsel. There would now be Queen's Counsel appearing in the case, which took 45 days for the judge to hear. And it was in that case that Sir Nicholas Wall, as he then was, led Ernest Ryder, who was a junior barrister. And the number of barristers who were in that case, who became appeal court judges or circuit judges and high court judges, quite remarkable, actually.
Yeah.
But the reason I remember it best of all is because I instructed Janet Smith, who became Lady Justice Smith in the Court of Appeal, because she taught me as much as I've ever learnt about case preparation and inquiring about the right issues.
Yes.
And she ably led the woman who succeeded me as the designated family judge, Her Honour Judge Newton, who's now retired as well.
Yeah.
But that was probably the seminal case that I will remember for all of my life. I can remember lots of other cases for lots of...
Yeah. But that was a template.
That was a template, yes.
Yeah.
On which I based all my subsequent preparation in relation to these sorts of cases.
Yeah.
And which has taken us all the way through to the public law outline.
Yeah.
After we went through the judicial protocol way back in 2000.
Yeah. And of course, she wasn't a family law specialist, was she?
She wasn't, but she was just utterly brilliant.
Brilliant. Yeah.
I did used to instruct her when she was a junior counsel to do the occasional case in the county court.
Yeah.
So she had some experience. But yes, she was a brilliant choice of advocate because she was by far the best advocate out of all of them in that case, I thought.
Yeah. So, and as a judge?
I've got significant number of cases that I can remember, and many of them for very bad reasons, because they involved horrendous stories of catastrophic injuries being caused to children by their parents or their carers. And equally, I can remember a private law case which will haunt me, I think, throughout my life, involving a mother who abducted her child, took her out to Mexico and then through to Canada. And I was having to deal with the father of the child appearing before me on a regular basis as we were trying to trace this child and track the mother, and eventually we succeeded in being able to do so. And eventually the child was returned to this country. The mother eventually came back after she'd served a prison term. I can't remember whether she'd served a prison term. She must have come back and served a prison term in this country.
Yeah.
But then I had to continue dealing with the case as I was able to transfer the custody of the child to the father, and eventually the mother made an application for contact. I was able to deal with that. The case was still ongoing when I actually retired from full-time sitting in 2014. And this child, who was 2 when I started dealing with her, I think must have been about 10 by that time. And fortunately, I occasionally bumped into the father, because he used to live in the middle of Manchester in the northern quarter, and I can remember speaking to him, and he told me how happy he was that his daughter now gone to senior school and actually at that time was seeing her mother again as well.
Wow.
It's quite remarkable, really.
Yeah.
But, you know, cases like that will live with you forever because it was a very complex case legally because of the international elements that were involved. And I dealt with it as a High Court case, and I occasionally had to consult with the President as to what I could or couldn't do.
Yeah.
But equally, there's another case which I dealt with that will always live with me because I had to give it absolutely top secrecy. And there's only 2 people that know anything about, or 3 people I think I'm right in saying now, know anything about what orders I effectively made in that case.
Right. So a complete blanket of...
And that was with the approval of the President at the time.
Yeah.
Yeah.
Yeah. When people think about a judge and making decisions, it can seem from looking from a distance like a very lonely occupation.
Yes.
Is that part of the reality of being a judge?
I think it is for a lot of judges. I never found that a problem. One of the things that used to sometimes perplex me was the way in which other judges seemed to always want to sound out a second opinion before they came to making their own decision.
Yeah.
I always thought that wasn't right, and I very rarely ever shared what I was thinking with another judge about a decision I was about to make, and only did it after I'd made the decision.
You're right.
And then I would find out what they thought, basically.
Yeah, yeah.
But having said that, I think it's true of barristers that they will often consult with each other about their cases in the same way that you referred to clinicians having multidisciplinary meetings where they would share their views and opinions to come to a decision.
Yeah.
I think a lot of barristers found that that was the case. And of course, the majority of judges used to be at the bar, certainly at one time. Whether it's true anymore or not, I don't know, because there seemed to be an awful lot of recent circuit judges have been upgraded from district judge status to circuit judge status, and many more people who were therefore solicitors in practice.
Yeah, yeah.
So,
yeah. If you could make any changes to the family justice system, what comes to mind?
I spent 9 years of my life writing protocols, procedures, helping 2 different presidents that I can remember, along with the help of Lord Justice Ryder, write all sorts of formulaic outlines as to how things should be done. I don't know whether or not those are all still in force or not. But there was a time when one of the presidents said that Manchester has more protocols than Gatwick has runways, referring to me and my predilection for trying to get everything down in writing to teach people how to do it better, or to do it right, should I say.
I do remember when I was giving a valedictory speech at your retirement ceremony, holding up a packet of a 20 packet of Embassy cigarettes in one hand and a 3-meter roll of lining paper in another, and saying,
yes,
one of them is the business plan that never got put into effect, and the other is the protocol for dealing with incoming mail at Manchester County Court. So we all knew about the protocols.
But what I would say about change for the future, if I could do anything, it would be to reintroduce legal aid for private proceedings, because it seemed to me that the removal of legal aid from most private law cases significantly disadvantaged not only the parents, but also the children,
Yeah.
I have to say. But I don't think that this government is likely to go down that route. And indeed, what I have noticed, even though I've not been paying much attention to what's happening in the family justice system, is that there's rarely ever any mention of the family justice system by any of our current crop of politicians. So who knows where it's going to go.
Yeah. And just one final question in. What gave you most satisfaction in your career? Being a solicitor or being a judge?
Being a judge. And I say being the DFJ in Greater Manchester because it was the biggest circuit on court, and it was a challenging job which I actually enjoyed doing despite all the hard work that it entailed and the difficulties that came with it in terms of trying to manage judges, magistrates and others.
Yeah.
But I'm just very proud to have had that opportunity to be able to serve the community and in particular the children, I have to say.
Yeah. Well, I'd like to say that we enjoyed you being the designated family judge. We were proud to have you, particularly as solicitors. We were proud to have a solicitor taking up that position of responsibility and doing it in such a distinguished fashion, because not only did you demonstrate a dedication to the job, but you also showed a commitment to the entire family justice system. You made a point of letting everybody within the system know how much they were valued. Yeah. Not just the legal professionals, not only the social work and medical professionals, but also the court staff.
Yes.
The people without whom the building, the system wouldn't run.
Yeah.
And every parent, even those who knew that you weren't agreeing with them, you made them feel that they mattered. So, we all appreciated it. And of course, you have been recognised as being a commander of the British Empire.
Thank you for that, Michael.
Just like that distinguished friend of ours who's just died, Barry Humphries.
Yes.
Yeah. So,
yes,
Iain, I'm so pleased that you've been able to join me in opening the door to family law. For all of you who've joined, I'm delighted that you've been able to do that. And I hope you will do again in the future, because we've just had a taste of what it's like inside the family justice system. It's something which touches all of us. It's a law which governs and rules all of us, but it's our law and we should know about it, now know how it operates, and our voices should be heard. Your voices should be heard in telling us how it could be better, how it's affected you, and what you'd like it to be in the future.